This short video is intended to supplement Study Notes 2.2.1 on the meaning of a decision for purposes of the definition of administrative action in the Promotion of Administrative Justice Act, and is part of your coursework for PBL 310 Administrative Law at the University of Pretoria. So previously you've learned about why, in principle, conduct ought or ought not to constitute administrative action for purposes of PAJA. So in other words, you've learned a little bit about the ought question of why public power should be regulated by the administrative law. What we're going to learn about now is when conduct will qualify as administrative action so that it is in fact regulated by the administrative law and specifically the standards codified in the Promotion of Administrative Justice Act, PAJA. So to start with, we need to consider the elements of administrative action under PAJA. The first element is that the conduct, in order to qualify as administrative action, must be a decision. Second of all, that decision must be administrative in nature rather than legislative, executive, or judicial in nature. Thirdly, the decision can be taken by anyone, but must be either of a public nature or the performance of a public power or function. The decision must also impact people in a specific way, in that the decision must have an adverse effect on rights, must also have a direct external legal effect. Finally, the decision must not fall with any of the conduct that is explicitly excluded from the meaning of administrative action in Section 1 of PAJA. There is a long list of specific exclusions. So, to represent these requirements graphically, you'll see the central bubble represents administrative action, and each subsequent bubble, that of decision, of an administrative nature, of a public nature, with an adverse effect on rights, and not covered by any of the exclusions, is represented in the drawing that we've provided for you. And we will start by focusing on the meaning of a decision, the first requirement for administrative action to be present. Of course, in order for administrative action to be present, all of the requirements must be satisfied. So what does the first requirement entail? The first requirement of administrative action is that the holder of public power must make a decision. The term decision is defined in PAJA itself, and it's defined in an inclusive way, broadly, and covers decisions that are proposed to be made as well as decisions already made. It also covers inaction in the sense of a failure to take a decision. And you can imagine a situation where someone applies for an ID document, but no ID document is issued to them. In that event, there has been a failure to take a decision. PAJA recognizes that such conduct can adversely impact on rights, and so includes that kind of conduct within the definition of a decision. In other words, creates the potential for a failure to take a decision to be subject to review on the grounds in Section 6 of PAJA. Now, there are two key attributes of the term decision. The first is that a decision necessarily entails a choice between two or more options. So you guys can think of when you want to buy a cell phone and you must make a decision to buy a cell phone. You could choose either, for example, a Samsung or an Apple cell phone. The fact that you have more than one choice means that you must make a decision and select one or the other cell phone. Likewise, with administrators at administrative law, they take a decision when they make a choice between two or more possible options. Now, the fact that administrators must make a choice between two or more options means that their conduct cannot be merely mechanical and must entail the exercise of discretion. And there are two cases that illustrate these requirements of decision making. In the first case, game vest, landowners sought to challenge the first step in the process of a land claim in anticipation of a land claim being accepted. Now, it's only possible to lodge a claim if a number of formal requirements have been met, which are checked by an administrator against a checklist. Now, the court found that the landowner's challenge was premature, since the land claim had merely been lodged and received. All that had happened was that a list of objective facts had been present and checked, which enabled the claim to be lodged and be received. The mere act of checking these facts and receiving the claim did not amount to the exercise of a discretion. That act was simply mechanical conduct. As such, the receipt of the claim could not amount to the taking of a decision as defined in Section 1 of PAJA. The conduct was merely mechanical. Now, it's also been held in Paniti that a decision will not be taken where conduct occurs by operation of law. Now, Paniti concerned a school teacher who had been absent from work without excuse for an extended time. She was dismissed by the principal of her school in terms of legislation governing educators, which provided that if she was absent for longer than 14 days without excuse, she would be deemed to be dismissed, unless her employer directed otherwise. Now, the teacher wanted to claim that she should have been consulted before her dismissal, whereas the Department of Education argued that no decision had been taken by the principal because he had not exercised any discretion, with the result that his conduct did not amount to administrative action subject to the requirements of procedural fairness. The department's argument was based on the fact that all that the principal had done was confirm the effect of the legislation, such that the teacher's dismissal had occurred by the operation of law, in other words, by putting the legislation into effect, and not as a result of the exercise of any discretion on the part of the principal. The court agreed with the department's argument and held that no decision had been taken in relation to the teacher since the principal did not exercise the discretion. Rather, the teacher was dismissed by operation of law, and as such, the teacher's application to review her dismissal on administrative law grounds failed. So the game-based and the Paniti cases illustrate two aspects of when discretion will not be exercised. The first being when conduct is purely mechanical in nature, and the second is when conduct occurs not because of any choice of the administrator, but rather because of the operation of law. The final thing we need to note about the definition of a decision is that it prescribes that a decision for purposes of administrative action must be administrative in nature. Now, the requirement that a decision must be administrative in nature is really to distinguish that decision from decisions that are either judicial, executive, or legislative in nature. But we need to think about what the typical features of an administrative decision would be. This picture on the slide is intended to illustrate to you the typical kind of decision that would be regarded as administrative in nature. This is because here you have the holder of public power, the police officer in the picture, who is in an unequal relationship with the person over whom she exercises that power. So in other words, the police officer has more power than the road user who gets pulled over by the police officer. There is a relationship of inequality between the police officer and the road user. That's precisely why we pull over when a police officer asks us to pull over. Second of all, a decision of an administrative nature has the typical feature that the holder of public power acts so as to give effect to legislation or policy, in other words, to implement legislation or policy, in order to achieve the running of the state. So when that police officer pulls you over and writes up a ticket, she is doing so to implement or put in action law or policy that requires her to issue a ticket to you. And when she issues a ticket, she is at least in theory engaged in the running of the state. She is ensuring enforcement and compliance with traffic laws. And the final typical feature of a decision of an administrative nature is that the holder of the public power is usually a member of the public administration. So an official in the executive branch of government that forms part of the public administration and is engaged in the day-to-day running of the state. This official is to be distinguished from members of the central or high executive, who are not usually engaged in the day-to-day running of the state. So whilst you'll typically, in your day-to-day engagements with the state, come across a police officer, you won't typically, in your day-to-day engagement with the state, come across the Minister of Police, who is in the central or high executive. So now that you understand the typical features of conduct of an administrative nature, the next part of the course will ask you to understand the marginal situations. So the situations where members of the judicial, legislative, and central executive branches of government could potentially be performing conduct or exercising power that is administrative in nature. Now, this is of course possible because, as you are well aware, the rule in SAFU is that in determining whether or not conduct is administrative action, what matters is not so much the functionary as the function that is performed. So it's necessary to look not merely at who is performing the conduct, but also what conduct is performed. This, of course, means that anyone in any branch of government can potentially perform administrative action. What we've highlighted in this video is that typically certain officials doing certain things will be performing administrative action. As you go forward, you will be concerned with the more marginal cases.